Well, hello everyone, and welcome to tonight's kind of hotshot episode where we're gonna have a little bit of fun here. That got askew. So give me 1 second here to set things up because I thought I had saved stuff on YouTube, but apparently I hadn't, and I gotta go fix it. Means I'll probably have to do it on Rumble too. So tonight's kind of like your normal extra episode. I have a rough idea of what I have planned, but let me tell you, my plans are not very solid. I do have a quick thing that we will definitely start off going over, and that is I've been doing a lot of reading because we have some new information about AZRH since the last time we left off. Basically, since we have to learn things in medias res as usual with this company, as opposed to, I don't know, clear, definite statements filed with the public so they're aware of what's going on, we learned via Oil Mutt about this most recent lawsuit, which has actually been pending since the 14th of last month. Was filed in February, but not February, January. It's February now. Of course, no notice was given, no announcement by the company, no anything to indicate what the flippity fuck was going on. But here we are now. We now know that it's going on, and news moved really fast as soon as I got off of work. Because this situation was pretty live at the time. So we first learned about the lawsuit, which is over here. It's Bazarian Holdings, which was the company that formerly held AZRH, and then Vision Oil and Gas. So basically, they are holding Vision Oil and Gas in default of this promissory note. So let's go over the common facts here really quick, because this is going to be a touch important to kind of sort of understanding what's going on here. Save that. Sorry, I'm having to set things up as I'm going along here. Yep, that's right. Okay, we'll leave that alone for now. That's good enough for at least our purposes. Okay. So Josh Cohen is the president and treasurer of defendant. Stock purchase agreement dated October. This is all stuff we kind of knew about. This whole purchase agreement that's disclosed here. So let's get back to this. So simultaneously on October 4th, defendant and plaintiff entered into a promissory note agreement for $115,000 for payment of services rendered by plaintiff pursuant to defendant, who promised to pay plaintiff the principal amount. And it should be clear here that it's in shares and in cash. And that's going to be key for how we go along from here, because what you're going to learn, I'm going to try and take a step by step as we go through this, but you're going to learn that this transaction is highly convoluted for very shady reasons. Ensuing, well, you're not going to get any drunken tirades from him anymore, unfortunately. He's been a little bit better about that, which, as a CEO of a company, I'll give it to him. I'll give it to him. That's an improvement. However, it doesn't change what we're about to talk about here. So, okay, so we have a part share, part cash transaction in the stock purchase agreement. So then simultaneously, they then make a promissory note and the plaintiff and the principal amount. The First Amendment was made on December 1st, whereby Mr. Cohen agreed to a default penalty. Now, this is the part that threw me off because this is not exactly super clear. The way they make it sound like is Cohen, as an individual, defaulted. Default penalty. The Second Amendment, dated January 3rd, 2025, entered between Mr. Cohen and plaintiff, whereby Mr. Cohen has extension of payment due to Mr. Cohen's inability to pay monies owed to plaintiff. The Third Amendment statement on June 7, 2025, entered between Mr. Cohen and plaintiff, whereby Mr. Cohen agreed to a scheduled payment plan to pay monies owed to plaintiff. Mr. Cohen began making monthly payments and then failed to make the required payments. On January 7th, he individually entered into a debt assignment and assumption agreement with the defendant. Okay, so yeah, this clears it up. So all this was owed by Josh Cohen. This money was then transferred to the company. So Josh Cohen's debts in this transaction were then transferred to the company. Now you may notice none of this is fucking disclosed anywhere in here. I mean, all of these Bilzerian Holdings things were debts purportedly by the company. None of it was ever disclosed as debts held by Josh Cohen, which, think of it as a layer cake. This is the first layer of the shadiness. We've got layers. It is like a wedding cake. There are towers and layers to how scummy this transaction is. Just set tight. I was gonna get some wine because we're gonna be some classy fuckers tonight. If we're gonna be dealing with some drama, shitco OTC stock craziness, might as well get some wine and just ball out. We got some umeshu, which is Japanese plum wine. So let's get it going. So on January 7th, Josh Cohen, this also, if that wasn't clear, like 7 days, a week before this lawsuit was filed, Josh Cohen enters into agreement transferring the debt he owes to the plaintiffs to the now defendant company. Like, you cannot make this shit up. So, once that happens, all the money that Josh Cohen owes that we've discussed above here, the $115,000, the back dude $50,000, and all this is now owed by AZRH. That is what's going on here. Meme stocks, yeah, that makes sense. So once that happens, they go ahead and file this case for breach of contract and are going to file this. So all hell breaks loose on X at this point because we're like, oh, well, this sounds like exactly what we figured was going on. Some shadiness, interested party transactions, all of that stuff. Oh, there's a little seal thing that I have to take out. Oh, smells very peachy. So this is stage one. So Josh first gets on the interwebs and says that, we've disclosed this multiple times. Where? Point to your financial statements where you disclosed that you were going to take monies you owed, put them on the company's balance sheet, and then get sued for them. All right. Sure. Why not? So, that's stage one of this. So he's like, hey, we disclosed this, and we're going to do this is a coordinated lawsuit to allow for a 3A10 exchange. Keep that in your mind. Like, tuck that away in the back of your head, what that is. Maintained by a leak out agreement to prevent an unnecessary harmful amount of dilution. Hold on to that one for a sec as well. An unnecessary harmful amount of dilution. He goes on here. I have this again because the only time he starts talking about this lawsuit is once it becomes public, which again, this lawsuit has been out. As we know, continue session. It's been out. Well, I mean, I can just go to the file stamp up here since the 14th. Like, it's almost been an entire month. Radio fucking silence. No one, not a shareholder, no press release, no statement on X that I could find at least about this lawsuit. And then suddenly when people mention it, oh, well, actually we have a settlement already put together. Which we're going to get into this whole 3A10 settlement thing. Don't you worry. And so he says it was a coordinated lawsuit. I was highly skeptical about that. But we did get a response from Belzerian Holdings. Yes, it is a coordinated lawsuit, which, call me crazy, if a company has a debt obligation to a debtor, the simplest way to resolve that is, well, I mean, first of all, just pay your fucking bills. That's always the easiest way to solve things. I mean, at work, I deal with debtor payments and back due all sorts of stuff. Like, always the simplest way to handle this is just fucking pay your bills. But for a company, if you can't pay your bills with cash, there's several ways to handle this. And we've seen this with several companies we've covered, whether it be, AMC or turn up the gain a little bit. There. Okay. So whether it be AMC or, Beyond Meat or I mean, even if you want to get down to Bed Bath & Beyond, that's a really extreme version. But like AMC and Beyond Meat, they reorganized their debt. They changed it to convertible bonds, or they did a debt for equity exchange, which is exempted already. What we're getting into is the deep-seated things here. A deep, intricate part of securities law known as the Section 3A10 exemption, which is another exemption much like the exemption for a debt for equity swap. If you have a debt and you exchange it for shares, then those are exempt from certain exchange laws that allow, like swing trading and things like that. Well, what we're dealing with Section 3A10 is, well, what if it's part in cash and part in, equity or debt or some other, thing here? Can we still like say it's a property interest, or we did part in property and cash, or some other payment that's due that's not strictly cash, it's some sort of obligation. Can we still get it exempted, SEC? Can we still do that? And, yes, but it's complicated. So, this is straight from the SEC's website. Just print more stock. That's always the answer with these shit codes. Just print more stock. Just fucking get the it's like the US Treasury. How do we fix a problem? We'll just spend our way out of it. Print more dollars. Just print more shares. It's all right, guys. Totally fine. No ramifications whatsoever. So, under Section 3A10 of the Securities Act, it's an exemption from the Securities Act registration for offers and sales of securities in specific exchange transactions. Before the issuer can rely on the exemption, the following conditions must be met. The securities must be issued in exchange for securities, claims, or a property interest, and they cannot be offered for cash. Okay, so, we have a debt obligation that has not been paid out. That is technically not cash yet. I mean, if it was paid out, it'd be in cash, but it's not in cash yet. So, it is a property interest. Property interest or a claim. You owe us money. A court authorized governmental entity must approve the fairness of the terms and conditions of the exchange. The review court or authorized government entity must find before approving the transaction that the terms and conditions of the exchange are fair to those to whom securities will be issued. This is key. Has nothing to do with existing shareholders. They must find before approving the transaction that the terms and conditions of the exchange are fair to those whom the securities are being issued. Not current shareholders, just the parties interacting in the exchange. Okay, just so we're clear on that one. And be advised before the hearing that the issuer will rely on Section 3A10 exemption based on the court's or authorized government entity's approval of the transaction. Ooh. This is why they're going this route. You see, if it was a debt for equity obligation, maybe shareholders might have some say, or they might be able to intercede, like what happened with AMZ and Antara Capital, if their rights are being violated. But here, the rights of existing shareholders are not considered. They're not considered at all. The court or authorized government entity must hold a hearing before a fairness and terms and conditions of the transaction. A government entity must be expressly authorized by law to hold the hearing, although it is not necessarily necessary that the law require the hearing. A fairness hearing must be open to everyone whom securities would be issued in the preceding proposed exchange. Again, current shareholders have no fucking say. Current shareholders have no fucking say. We'll make that clear. It is just the two parties involved in the transaction. Adequate notice must be given to all those persons, which is why Josh Cohen is scrambling around trying to cover all this up. He had no obligation to tell his shareholders. And if Oil Mutt had not found out about this, then nobody would have fucking knew. And he had no obligation to tell anyone other than Bilzerian Holdings. Just so we're clear on that one. There cannot be any improper impediments to the appearance by those persons at the hearing. The Section 3A10 exemption is available without any action by the division or the commission. The SEC is what they mean by the commission. Issuers that are unsure whether the exemption is available for a specific contemplated transaction may, however, seek the division's views by requiring a no action position from the division, i.e., you can ask us if you're fucking up or not. And that's pretty clear there. No time reactions, yada 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 yada. So what's going on here is, unlike normal transactions that would happen, like you have a debt issuance that needs to be approved by shareholders, or a securities issuance that may need to be approved by shareholders if you don't have already issued shares. This does not require any sort of shareholder approval. You can go, so long as the two parties involved in the transaction, or however many parties involved in the transaction, they can do it. If that doesn't sound fucking shady to you, don't worry, I found better. I haven't read this yet, but this is going to be, I bet, pretty interesting. So this was a Michigan Business and Entrepreneurial Law Review. 3A10 financing, new predatory financing using the Securities Act. Well, I mean, it's not new law, but I assume the implementation for certain people, it's new. This was back in 2016, so fairly recently. It's a decade old, but considering the article that I just got done reading was from 1999, this is definitely more up to date. Some of the statistics and stuff they may use could be different. Um, this may take a bit. This may take up all of our time. I don't know, but I think it's important that shareholders know that they're about to be fucked, as if they weren't already by investing in OTC shitco stocks. Oh my goodness. All right. Bring this over. Fix this. And let's let it rip. Introduction. The Section 3A10 exemption of the Securities Act of 1933 is meant to exempt securities transactions where a fairness hearing by a judge or government agency's ruling replaces the usual registration requirements. Recently, there has been a rise in 3A10 financing schemes where a third party investor, a 3A10 financer, offers to purchase the outstanding debts of a company from its creditors in exchange for discounted and unregistered shares of the stock. In a traditional stock issuance, a company must file a registration statement describing the company's properties and businesses, the securities to be offered, information about the management of the company, and financial statements certified by independent accountants. However, a 3A10 settlement simply requires that an action be brought against a company for outstanding securities claims or property interests, after which, in a fairness hearing, a judge or agency must accept or reject the terms and conditions of the settlement as fair to all persons who it is proposed to issue the securities. Those issuing the securities and those who already own the securities are afforded no such protections. That means if you're a shareholder or even say the company, like your consideration of if this transaction is fair to you, the shareholder, you, the equity interest holder, or even the company, is not considered, which is really kind of crazy when you get down to it. This work explores the Section 3A10 exemption in greater detail. Part 1 discusses the background and history. We'll probably skip over that. Part 2 introduces the modern trend of 3A10 financing for small and public companies. And Part 3 discusses some of the harms. So we'll skip over the legislative history and stuff like that. It will be interesting. Maybe I could do a video on all of this. And come back to it because I get the feeling it'd be really interesting. So let's skip to part 2. Lewandowski and the birth of 3A10 financing. Over its history, the 3A10 exemption has been used for mergers, reorganizations of companies, and settlements of private litigation. Over time, the SEC has issued no action letters and guidance to interpret its views when the use of a 3A10 is appropriate. Further, the SEC guidance seems to suggest a very broad use for 3A10 exemptions based on the following conditions. We just went over those, so we won't need to read them again. In Lewandowski, the SEC alleged the private litigation settlement using the 3A10 exemptions were for capital raising, which was an improper use of the exemption. The SEC stated in its complaint that Lewandowski developed an illegal strategy for penny stock issuers to pay off past due debts, while at the same time raising additional capital through improper use of 3A10. The SEC went on to state that Section 3A10's exemptions were not available where certain terms and conditions of the settlement are not present to the court for consideration at fairness hearings, nor in the exemption available for capital raising. According to the SEC, the plan began in 2004 when Unico, the company issuing the stock issued at least 17 convertible debentures to Lewandowski operated companies, which allowed the companies to convert the debentures and accrued interest into shares of common stock at 50% of the closing bid price. If either party requested the conversion, Unico was required to issue unregistered shares to the debt holder, either through a transaction pursuant to the registration statement or an application of the exemption from registration. At the time, Unico was a business development company under the Investment Company Act. And in a 3-year span, more than 50 pre-settled lawsuits were filed under the pretext. For Unico alone, less than $4 million in debt was converted into, Jesus Christ, hundreds, thousands, millions, 8.9 billion shares. Yuck. Which at the time they were issued had a market value of $28 billion. Or no, $28 million. Excuse me. Whew. That must not have been a very. Wow. Even after that, the dilution's probably what fucked it over. The issuer would execute a settlement agreement with the financer pursuant to an agreement to issue unregistered common stock to the financer at a substantial discount to the private market price. The number of settlement shares reflected in the settlement agreement was always based on a negotiated discount of the market price and or a multiple of the face value. Following the fairness hearing, the 3A10 exemption was granted, and unrestricted shares were issued to the financier, who quickly sold the shares into the open market to public investors who were unaware of the dilutive effects of the new stock issuances. Again, because they don't have to be notified. The financiers subsequently remitted monies to the penny stock issuer that. Wait, what? The financiers subsequently remitted monies to the penny stock issuer that to the SEC made it a capital raising I can understand that suggestion. That's a capital raising transaction because you issued shares and you got a kickback. On February 10th, 2015, the SEC announced it had settled its civil action against all parties arising from the transaction. Private actions involving companies and 3A10 financing arrangements have exemplified the continued complexities of such schemes. Yeah, well, and that complexity is a danger because the more complex it is, the harder it is to understand. And sometimes the more intentionally hard it is to understand what the fuck's going on. In a basic 3A10 arrangement, a 3A10 financer brings a lawsuit against the company that will be receiving the financing. Within the initial lawsuit documents, it is stipulated that a 3A10 financer is to be issued unrestricted common stock pursuant to a reduction in price from its current market value. According to the SEC, of several companies, millions and sometimes billions of shares are issued to the financier, in tranches, which can be requested at any time by the financier as long as the issuer is below either. The requirements to have to. God, so long as they're below the reporting requirements for the SEC. So this just sounds like death spiral financing under a different name. This sounds exactly like the Bed Bath & Beyond transaction. In a press release by the companies who work with 3A10 financiers, it is indicated that they use the 3A10 investment for funding. Further similar to Lewandowski, companies are issuing more value in stock than the value of the debt they are. That is disgusting. Further similar to, they're issuing more value in stock than the value of the debt they originally sold to the 3A10 financier. Where have I fucking heard that before? From, from start to finish, these lawsuits can be filed and settled within 1 to 2 days, which is kind of what happened here. I mean, it took them a whole month. I don't know why, but like again, one 3810 financier calls the innovative financing structure a way to substantially reduce the transaction costs and time and become a long-term financial partner assisting public companies in financing growth and expansion by supplying innovative financing solutions and flexible capital. I guess that's one way to put it. Oh. This was the section that I screen capped. The harms of 3810 financing. 3810 financing is damaging to the companies being financed, the shareholders who own the stock before the transactions, and the marketplace as a whole. According to SEC filings, many companies engaged in a 3810 financing end up issuing between 8 and 40 times the original number of shares agreed upon in the settlement. 8 to 40 times the original number of shares agreed upon in the settlement. That's despicable. Disgusting. The flood of shares in the market could in turn make traditional offerings more difficult, as it may cause potential future investors to have reasonable trepidations about investing in a company whose stock price has fallen so precipitously due to death spiral financing. Oh, sorry, I accidentally added that in there. The investors who already invested in the company are damaged because their investment is devalued through dilution. Investors holding the stock of a company undergoing a 3810 financing will likely see a drop in the share price as a result of the number of shares entering the market due to the financing agreement. Unless the company files an A, they're on the OTC, bud, or documents with the SEC, the investor will likely never know of a 3810 settlement happened until the transaction is completed. Because again, there is no obligation to tell the shareholders, only the parties involved in the debt transaction. Jesus Christ, this is shady as shit. Where were we? Issuers may initially withhold information from shareholders in order to keep the stock price from falling, which is probably why, I mean, the stock price of AZRH has been kind of in free fall for a while now, but like, if someone was to get wind of this transaction, most intelligent people would get out of the way. And that's why these companies tend to not tell their shareholders about it, because if you know dilution's coming, most shareholders don't stick the fuck around. They price in the dilution like smart investors do. Shareholders who are notified may sell out of their position, not because the company lacks investment potential, but because the overwhelming number of shares which will be sold and the pressure on the company to create artificial fixes like reverse splits, which can reduce selling pressure. Yeah, because like reverse splits are not fucking bullish at all. The marketplace is damaged by a 3810 financing because it artificially devalues the stock. While stock offerings normally indicate success in a company, they're almost always dilutive. I'll agree with the last half of that. I mean, a healthy company will not need to do a bunch of share offerings, but I mean, a growing company might, in order to expand rapidly and exploit a growing market before it reaches profitability. So, I mean, I don't agree with the whole of that sentence, but I mean, I take where it's trying to go. It is likely companies accepting 3810 financing will not be able to absorb the type of dilution of a normal secondary offering, let alone an offering in which the financiers can ask for more shares to be issued as the stock price falls. Accurate, especially when you're on the OTC market. Worse yet, this gives the 3810 financiers no incentive to hold the stock as a typical investor might, because their value comes from starting up the share printer, as the Funky Soul Brother said, just and just selling out, and just getting the best price they can get, whatever the market can bear, and just they got so much shares from this financing, and as they said, sometimes even more than the actual debt was worth. So just fucking sell, just keep selling. What was it to us? It's pure profit. Fuck them shareholders. Despite receiving the stock at a discount, holding the stock is less beneficial when selling the stock drops the share price and triggers more issuances. Bearing in mind that a rational investor would not purchase stock certain to fall in price, and consider that a company's stock price is very likely to fall because the dilutive nature of 3A10 financing, silence to the market about the deal is key to a 3A10 financier. Oopsies. Oopsies. Could that be why it wasn't disclosed that this was the end goal of the transaction in your last quarterly statement there, Josh? Was that the reason you couldn't disclose it till now? Didn't want to disclose it till now? You and your buddy Blazarian Holdings there, huh? Huh. Oopsies. Again, props to Oil Mud. He's the one who actually found this case. So the possible violations of 3A10 financing. There are several potential issues presented by 3A10 financing. These issues will be discussed in the order in which a 3A10 financing agreement takes place. The 3A10 financier and the target company enter into agreement and file a pre-settled lawsuit in order to procure a fairness hearing. Judges in 3A10 financing settlements typically receive a complaint, a list of the claims for which the 3A10 financier bases the lawsuit, and answer, and sometimes a memorandum of law. A settlement agreement typically allows the 3A10 financier to request more discounted shares of stock at a price as the price goes down, and contains an adjustment mechanism. Let's take a look at that. Josh so helpfully presented it here. This settlement agreement and stipulation is made and entered February 9th, 2026 between Blazarian Holdings, the Texas Limited Liability, and background, defined terms agreement. Yep. I mean, this for all we know could be only part of it, not the whole thing. I mean, it's 4 screen tabs. Yeah, we know about the fairness hearing, conversions, issuance. Upon entry of the order and the filing of a stipulation of dismissal of the action, the company shall issue to plaintiff conversion shares in one or more tranches. Each tranche shall be issued at the conversion price. Well, we don't know how many tranches. That's not a good first sign. That's not a good first sign, guys. 75% of the lowest closing price of the common stock during the 30-day consecutive business days immediately preceding the issuance date of... They get a 75% fucking discount? Are you fucking shitting me? And it depends on when the tranche is issued. We don't even know, based on this transaction yet, how many tranches there are going to be and at what point they'll be issued. But each time you take the 30-day trailing average and you discount it by 75%. Winning. If over the 30-day period, the volume look-back period, the trading volume of the company's common stock is not equal to or greater than 5 times the number of shares issued to the plaintiff during the 30-day prior, the plaintiff has the right to has the right to reprice the conversion price to offset the lack of liquidity in the market by recalculating the conversion price as of the last day of the volume look-back period. So not only do they get a 75% discount and a row of tranches that we don't even know about, they also, if the if the shitco OTC stock is so illiquid that we can't make a fucking market, we can reprice the shares again so we can get more fucking fat out of this pig we're fucking slaughtering. I'm so glad that Josh posted this. Thank you, Josh. We had to like hit you with the cattle prod to get transparency, but I'm glad you finally came through in the clutch. The company shall continue issuing tranches sufficient to generate proceeds such that the aggregate remittance amount equals the claim amount of $630,000. You know, I can't help but wonder, like, this original debt was what? Let me find it here. So this was original note for $115,000. Josh, that Josh owed, to be clear, that Josh owed, not the company. Josh owed it, to be clear. That he then saddled the company with. After, like, spending all this time not fucking paying it off, so that he got this fucking default penalty of $500 per calendar day, and then made this, like, promise to pay $50K of it. Who knows if that ever happened. And then, you know, made a bunch of other promises, then flipped it into the company, and suddenly this debt that if he had done this October 2024 for $115,000, but no, it's for $630,000 because he fucked around so long playing with his dick in fucking New York, that now, like, the company and its shareholders are obligated in this shitty fucking death spiral dilution agreement to pay back this over $500,000. Are you fucking serious? Are you fucking serious? All debt not yet converted to shares is still valid, outstanding, and owed to the plaintiff by company. Yeah, and notice, like, I keep using death spiral financing because this is exactly what it fucking is. Because they can not only determine the amount of tranches, or tranches, however you want to pronounce it, tranche. They not only can determine the amount of tranches, and there can be fucking, as far as this agreement's concerned, an infinite fucking amount of tranches. They can also reprice it, and as the company keeps death spiraling downward and getting more and more illiquid, they can readjust the price further and further down until they get paid at their $630,000 amount. Or, as the paper from Michigan so clearly pointed out, it could end up being more. Who fucking knows? All conversion shares are fully earned, permanently outstanding, and shall not be returned, surrendered, or canceled for any reason. Well, there you go. Delivery. Within 5 trading days after entry of the order and filing the stipulation of dismissal with prejudice, the company shall cause its legal counsel to issue an opinion to company's transfer agent in the form and substance reasonably acceptable to plaintiff and such transfer agent that the shares of common stock to be issued as the initial issuance and any other additional issuance. Yeah. That's just, lawyers doing lawyer stuff. So that'll go to the DRS and they'll get it all settled so that the shares can be issued. Cool. Company shall issue additional tranches until the claim amount is fully satisfied or the company is fucked and bankrupt. Peace! Yeah, that's definitely mutually beneficial for the company and Belzerian Holdings. I mean, the more I read, the more no, definitely fucks the shareholders, definitely fucks the company. Really great for Belzerian Holdings and Josh, who got to take $110,000 and dump it off on some OTC schmucks to pay his bills for him. Fuck you. Wow. Glad we got that out of the way. Yeah. I could probably go on reading that article, but yeah, they go on about pre-settled lawsuits, which we got here, settlement agreement, time issues. I mean, it's just an interesting article. I mean, it's 22 pages, so it's kind of a light read if you want to read it. Oh, hey, here. This is kind of interesting. They, unlike me, they actually give solutions to fixing this problem. Well, you know what? Let's go ahead and read those and be generous. I mean, this person did have the time to take the time out of their busy schedule, being what? Oh, being a professor at a law school. Let's be generous. While it's been suggested further safeguards are not necessary in 3A10 transactions, whoever said that must be fucking high as a kite. Evidence presented in the previous sections indicates a need for additional safeguards to protect the system from this sort of financing. Yeah, no shit. The SEC needs to bring enforcement actions against 3A10 financing companies. Yup. 3A10 financing bringing pre-settled lawsuits against companies in order to have a fairness hearing where normally the lawsuits related to the claims would be brought as part of a dispute between the parties. Yeah, when the parties are coming into the lawsuit, not as adversaries, acting on each other's best interests, they already have a predetermined conclusion that they're trying to get to. That defeats itself. That's not how courts are supposed to work. And it's why when you have settlement talk hearings in Delaware that you have these sort of like fairness hearings where other parties to the transaction can come in and like there should be a shareholder presence in this. There is none. Not a single fucking bit of one. And that's kind of the chief problem here. Shareholders don't need to be noticed about how the company's about to fuck their investment interest. But like in a normal fairness hearing, like the other parties to this transaction get to have their say in front of the judge, and the judge has to consider all avenues. And when two partners, plaintiffs and defendants, agree on a settlement, they're no longer opposed parties, and it defeats our adversarial system. So you have to have some sort of other like party to act on the interests of the other people who are not participating that are affected by this outcome. A company is perfectly able to purchase unpaid debt contracts and enforce them. If the two companies had the ability to trade outstanding debts for shares without the courts, they probably would. Yeah, it's called a debt for equity swap. You just fucking do that. But of course, that wouldn't allow nearly as much dilution protection and all this other stuff. I mean, you could write it in there, but then again, you'd have to get shareholder approval. That's the reason why they like doing this fucking loophole, because it cuts the shareholders immediately out of it. Not like it would matter in this case too much because Josh has super voting majority, but that is neither here nor there. 3A10, however, is not intended to help companies raise capital using fairness hearings. It is intended to give those with a prior dispute an opportunity to settle by exchange shares for a bona fide claim. Current 3A10 transactions are in direct opposition to the legislative intent of 3A10 and should be seen as outside of the 2008 SEC guidelines on the appropriate use of Section 3A10. The judges conducting the fairness hearings only review the settlement documents for a short period of time, as little as 1 to 2 days before the hearing, and in some cases require the hearings to be held in 5 minutes. 5 minutes or less? Are you fucking serious? This brings into question whether judges conduct a fairness hearing at all, given the court's interpretations of what enumerates a fairness element should be. Yeah, black coal Texas tea, the Beverly Josh Billy. That's a pretty good one. Even if they did have time, the judges are left without material information, such as the market value of the shares the 3A10 financier would receive. Although unlikely, if a 3A10 financier could provide the market value of the initial shares proposed in exchange for the outstanding claims, this would not satisfy 3A10's requirement that the exchange be for bona fide outstanding shares because the financier most likely included a clause in a pre-settled agreement that allows them to take the shares at a discounted price, sell them freely, and collect more shares as the share price plummets. But even if the securities and the hypothetical future securities were deemed bona fide within the language of Section 3810, a judge could find that that while the fairness of the initial distribution of shares was sound, the additional issuance of shares exchanged for debt are not being exchanged after a fairness hearing and are thereby not freely tradable, as the shares are unregistered and have not met the requirements. Yeah, that's a good way to handle that. At minimum, the SEC needs to make its guidance more clear as to the requirements and exceptions for all parties involved in 3A10 financing. First, the SEC needs to officially adopt the fairness standards set forth in the case law. The court should be required to analyze the recommendations of counsel, the scope of the record as an indication of the adequacy of the investigation into the facts, the apparent alternatives to the settlement, the nature and volume of responses from those receiving notice of hearing, the opportunity for direct participation in the process of obtaining full disclosure, the liquidation value of the business before and after the proposed settlement, whether the settlement was fair, and whether the settlement was reached after fair dealing. Yeah, that last one, really key, especially in this situation. These factors will require courts to look deeply into 3A10 transactions and ferret out potential issues. Next, the guidelines should speak specifically to whether shares may be taken by the financier after the date of the settlement and how many shares is significant enough to trigger the SEC's own previous guidance. Finally, there should be congressional support to amend Section 3A10. First, the exemption should be placed back into Section 4 as a transaction rather than a security-based exemption. The legislative accident of moving 3A10 out of Section 4 caused confusion. Yeah. I'm still like the big thing here is I think there should be like more of a shareholder voice in this. Like this sort of transaction directly fucks them over, and they should, in any fairness hearing, as stakeholders in the company who have the ability to appoint the board and all this stuff should be able to come in and say my rights as a participant, an equity holder in this company, are being violated by this shitty fucking agreement. But yeah, that is that. We're going to move on to some things that I didn't get to. So I need to cue them up here. FHFA. Of course, we're doing Pulte now. 1 second. Recently we had I had some stuff for last Saturday's episode cleared up for when Amy was expecting Amy was going to be with us so we could talk about good old Bill Pulte. Unfortunately, Amy was all worn out, and that's totally fine. So she works hard running her own business, so she was not able to make it. But I still wanted to talk about some of this stuff, but I didn't want to bore Platinum with it because she generally doesn't care too much for this sort of Bill Pulte stuff. So, let's see here. So we're gonna talk about Bill. We're gonna talk about Fannie and Freddie. We're gonna talk about some stuff dealing with that now that we're done with our friendly lawsuit segment. Um, let's see here. Privatizing Fannie and Freddie is risky. Yeah, you don't say. Would it be a win for taxpayers or Trump donors? Probably Trump's donors. After a turbulent first year, the president's return to the White House, 26 could bring something. Mortgage giant underpins roughly 70% of U.S. Yeah, we know what Fannie and Freddie are. We know who Bill Pulte is. He's kind of a fucking piece of shit. Though I am kind of curious what they have in here. Critics have repeatedly questioned him for his lack of experience. Well, yeah, because he has no fucking experience in mortgages. The FHFA maintains that Pulte has the legal authority to make himself chairman. Sure, but I mean, does that make it right? It's just also raised eyebrows by bringing to bear the agent's investigative powers. Yeah, we'll get to that. We'll get to that. So some news did come out about that. Where was it? Oh yeah, that the criminal referral against Adam Schiff was quashed. That was kind of I think already known news, but it explains why Adam Schiff is planning on potentially suing over that. Be interesting to see what comes of that, because we know all of those referrals were fucking bullshit, and basically Pulte trying to get good with Trump, to exchange political favor. Talk about selling shares of Fannie and Freddie throughout 2025 has flowed the idea of a stock offering to sell at least a portion, which makes no fucking sense. Like crazy mortgage, Pulte's crazy mortgage scenes, yeah. Entirely up to the president what he'll decide to do, yeah. This, well, we'll get to that. Key Trump donors could make billions. Yeah, well, why exiting conservatorship is tricky. The idea under conservatorship is that you kind of work through the problems, put these institutions back on a sound financial footing. There are large companies, evaluations 100 billion. So if we were to sell a stake, sell a 3 to 6% stake, could work out to at least that. Keep that in the back of your head. Investors could profit by owning Fannie and Freddie stock before the 2008 crash, but the government was on the hook for far too much risk. The big thing here is that Bill recently got on. I'm going to have to put in some headphones so that way we don't get feedback city. Why is this not connecting? That's really silly. These should have been on the charger all fucking night. Why are these not charging? They're not connecting. This is really silly. Battery medium, why? This is so dumb. See if this.
Director, Chairman of Fannie Mae.
Cool. I assume you guys can hear that. Let's speed this up a bit.
And Freddie Mac, William J. Pulte. William, good to see you. Thanks so much for being here. What do you think the odds are that Kevin Warsh gets confirmed?
I think he'll get confirmed, and I think it's a really good pick. I think President Trump knows exactly what he's doing in terms of interest rates, and we need, frankly, a Fed chair that isn't politicizing the Fed and can actually restore credibility to the institution.
Look, I don't even know where to fucking start. Like, you guys are, like, this accusation and Amir shit, you guys are the ones who started politicizing the Fed. I don't know if you're fucking paying attention there, buddy.
You know, Maria, Jay Powell has just totally turned this into a political football. These should be very straightforward questions. I mean, why should somebody be spending $4 billion on a building? So time can't come soon enough for Jay Powell to be gone, and I think it's a great pick, and frankly, we're looking forward to it in the housing market to have a new Fed chair.
Well, what do you want to say to the critics who say, was it really necessary to launch an investigation into Jay Powell? The chairman's term is up in May anyway. Was this your idea?
Well, of course I wasn't involved in it. I don't work at the DOJ. I've actually never met Janine Pirro.
Bullshit! Bull fucking shit. The guy who fucking came in with a poster board to go after Jay Powell to try and convince Trump to do it. Get the fuck out of here.
My life, to be honest with you, but it doesn't take a rocket scientist to figure out something is deeply wrong with this building. Now, I'm in the construction business. President Trump is in the construction business. We toured the facility last July, if you recall. They have a thing called a reverse bathtub. They put in a new basement. They renovated the basement. The water tables are low here in D.C. You have the Potomac River. They basically had to create this reverse bathtub. I mean, what is going on? Who's getting paid for all of this stuff? I hope the DOJ gets to the bottom of it, but again, that's up to them, and that's up to the people that are looking into it.
And well, just to be clear, the investigation is about what he said about all of that, right? Was he honest and truthful with the Congress under oath? I mean, that's really what the investigation, not necessarily that he's spending all this money on the bill.
Honestly, I don't know what this.
Right, yeah,
honestly,
because Pulte, again, doesn't know what the fuck he's talking about. Can't keep on subject or on topic. Like, I'm not big on Fox News or Fox Business in this case, but thank you for calling him out for completely fucking dodging the question and not answering it, as Pulte is one to do.
But I can tell you, Maria, when you look at what his testimony was and you look at some of the things he said, when people lie about small things, they tend to lie about big things. And who knows where all this money went. $4 billion is a lot of money. You know, when we walked around, Maria, they had doors in there that
again, not answering the fucking question.
had wood that was put over the doors to protect the doors. And frankly, the Fed is like the premier institution, so I'm very confident and very happy.
This is for Freddie Mac and Fannie Mae, and the Freddie Mac portfolio, the mortgage portfolio, growing to $3.67 trillion as credit performance holds steady. Fannie Mae's portfolio sitting at more than $4.1 trillion as of December. What do you want to say about this? Are IPOs of these two companies still on the table, or is this off the table at this point?
Well, of course, President Trump keeps options on the table, all options at all times. We are ready to go for when or if the...
That's a great way to say you have no fucking idea. Well, we're keeping all ideas on the table. Like, that's fucking meaningless. It means you have no clue, you have no idea, you have no fucking plan. But of course, like, the Fannie and Freddie marks are going to, like, read into that whatever they want to. Bartiromo is normally good at calling out folks. Well, that's good to know.
President decides he wants to do that, but the reality is we don't have to do that. And Maria, I would just say, look at those numbers, 3.6 trillion, 4 trillion. Until this administration, specifically this president, came on the scene, nobody even knew that these two businesses existed. I mean, it's almost criminal that no other president utilized these companies. They tried to convince President Trump in his first term to sell them for $100 billion. Now we're doing a $200 billion mortgage bond buy that has already reduced mortgage rates. So this is what happens when you have good leadership in these companies, good leadership.
See, like, that's completely empty statements.
In this
like,
country,
he's saying
and I'm very
fucking
grateful that
nothing.
President Trump has been able to give us the air support that we need in order to make these big, bold decisions, which are going to fix this housing market that's been devastated these last 4 years under Biden.
So what are the odds of an IPO happening this year?
I think they're very strong, but I think it's very strong that President Trump wants to do something else. It's entirely up to him, and there's...
I think the odds are very strong, but I think that's also very strong that Trump might do something else. Again, nothing. These are nothing fucking statements. They mean nothing.
Only one person who knows, and it's him. It's not me, but we are ready to go, and we keep all options on the table.
Glad
we had all this cash, and the president decided to do this big mortgage bond buy. That actually helps the IPO, contrary to what people have said. So we have all options on the table.
Yeah, let's talk about that mortgage buy. The president obviously ordering Fannie Mae and Freddie Mac to buy $200 billion worth of mortgage bonds.
Okay, I'm not too concerned about that. What I am finding funny is what Amy had mentioned about good old Billy O. Was that, you know, now it's completely come down. Like, he's now saying it's 2 to 5% of Fannie and Freddie that's going to get IPO'd. It started out as 10%, then became 5%, and now it's like it might be 2.5 to 5%. We're not really fucking sure. I don't know. We'll think about it. You know, we'll think about it. Yeah, and that's what's in the article there. What I think is infinitely more interesting is we have some updates in the Fannie and Freddie thing. We got order deadline set. Let me do something real quick. I want to see what that was about. I saw it come up because I have this case saved on my alerts. Let's set it for, what is this? 2/9, so we'll do 2/6/2026 and see what that is. Run report. Okay, That'll give us, okay, good, minute orders. So, first, we got a joint status report. Let's jump to that first. So, this came out on the 6th. That was the other side of last episode. Good old variable percentages. Yeah, absolute word salad. So this in case you guys don't remember, or for people who don't know, this is a Democracy Forward had done a FOIA request on the Federal Housing Finance Agency for a slew of documents relating to Bill Pulte, um, the criminal recommendations that he had given over to DOJ, the Lisa Cook stuff, all of that. A bunch of other things, including his connections with James Fishback, which was also a bit of a matter of question. So this is the lawsuit because, FHFA did not respond to the FOIA, and so now they're trying to get this FOIA information. So pursuant to the court's January 7th, 2026 minute order, plaintiffs, Democracy Forward and defendant, Federal Housing Finance Agency, hereby submit the following joint statements. So they've completed their search of all the documents, gotten everything requested, and then we get defendant's position regarding the information sought. Defendant has proposed a reasonable production schedule for the requests at issue in the suit. It has completed the search and has agreed to swift production of straightforward responses. Our defendant has 38 requests ahead of 2025 FOIA 98 in the processing queue. So they're behind about. See, well, welcome to things in the Trump administration timeline where there is a lot of people asking for stuff from the government. Yeah, that's why there's this big old long ass queue, and they're wanting to find a way to manage it. Processing will take about a year and will be complete by January 31st, 2027. Oh, great. FOIA request 2025 FOIA 98, the Shift James referral request, compel at 10, concerns a matter of significant public importance for which timeliness in the release of responsive records is critical. Consequently, plaintiff requests that the court require defendant to produce the non-exempt portions of the 270 pages responsive records by July 2026. Yeah, I'd agree with that. The records that issue to the relate to the action taken by Bill Pulte involving referral of the sitting U.S. Senator Adam Schiff and presently serving State Attorney General Letitia James for alleged mortgage fraud. Because Director Pulte leads the regulatory agency with authority over the entities that possess the confidential mortgage records, the circumstances of these referrals raise serious concerns about his access to and use of non-public information. Yeah. Plaintiff does not seek extraordinary relief. Rather, plaintiff proposes a reasonable and modest proceeding schedule that would require a rate of processing fewer than 200 pages per month, with the completion by July 2026. This would allow approximately 45 days after defendant completes processing in the matter of defendant rights, the public significance of the requests. Yep. Plaintiff proposes processing rate more conservative than FOIA processing schedules routinely ordered approved by the courts. So basically, wow, okay, so that's why I was confused there. So basically, defendant's like, yeah, we got a lot of documents. We might get around to it by the start of 2027. Call us back later. And plaintiff's like, well, if it's going to take you that long and you got a lot to process, can you just get these done in a couple months and the rest we can wait till later? That sounds like a good way to handle that. As far as I'm concerned, because again, some of this stuff I would like to see, because I get the feeling that Bill's not going to come off looking very good. But we do have a minute order. In light of the parties' DI 12, which we just read, joint status report, the parties shall file another joint status report by 7/15/2026, updating the court of the status of the matter. Plaintiff additionally requests the court order the defendant to expedite the process of certain documents. Such request for a court order generally must be made in a motion. Oh, geez. We're going to get a whole drug out motion hearing. Hopefully they expedite it so we can at least get it done in a timely manner. Motion must state with particularity the grounds for seeking the order. Because the plaintiff has neither filed a motion nor stated with sufficient particularity the court's authority to grant such relief, we're going to have to go through that rigmarole. And well, I mean, I guess rules are rules, but that kind of sucks. Let me see here if we can find. I know Ocelot had linked to it. Oh, that's the motion to transfer. This is what I was looking for. Doink, 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 doink. We'll see how long this takes us to get to. It should be DI 32, right? Ah, yes, Judge. It's Judge Sparkle Sukdanan. Yeah. The judge with the best name ever. As we get ready to talk about Elon Musk. Some of the stuff here. Update some of the tags since we got to this. Awesome. I don't know how much of this I'm going to get through reading. We do know the background. This case is the lawsuit about Elon Musk not disclosing his purchases in Twitter. Gosh, that seems like a decade ago. It was only 3 years, though. The SEC assumed this is the memorandum opinion of Judge Sparkle Sukdanan denying Elon Musk's motion to dismiss on the Section 13D claims for disclosing his stake in his stake in Twitter. We're going to skip over the background because I would hope most of us are fairly aware of that situation. And we'll get to the discussion. The court first addresses Mr. Musk's. I don't know how long we'll get to this because this is like 40 pages. We may do a lot of skipping around depending on time. But I kind of want to see the First Amendment ones because I started reading that and they sounded pretty fucking silly. The court first addresses Mr. Musk's arguments in favor of dismissing the SEC's complaint. He argues, A, that Section 13D is unconstitutional under the First Amendment. Man, judges hate that one trick where if you get accused of a crime, you just say that it violates your First Amendment rights to be held accountable. Everyone hates that one trick. That one trick. Is it actually streaming over there? It says it is. Okay. So it is. All right. Cool. Alrighty. Switch to this. The court first addresses Mr. Rule 13D is unconstitutionally vague. What? That the SEC is selectively enforcing Section 13D against him. Sure, whatever. The SEC commissioners are insulated by unconstitutional protections from removal. What does that fucking have to do with your case? Like, nothing. Fucking nothing, bro. First Amendment. First Amendment protects the most sacred of rights. I love that she is about to go into excessive detail about the case law around First Amendment constitutional claims and litigation, and it's going to immediately expose how clownish Elon's whole case on this is. The First Amendment concerns are paramount where the government compels a speaker to endorse a position contrary to his beliefs or to affirm a belief and an attitude of mind he opposes. Mr. Musk argues that Section 13D cannot be enforced against him because it unconstitutionally forces filers to speak against their will and disclose their investment positions and intent. Presumably, Mr. Musk is referring to Section 13D's requirement that certain purchasers of securities must disclose if the purpose of their purchases or prospective purchases is to acquire control of the business of the issuers of the security. As with many First Amendment challenges, much hinges on the court's selection of the test for resolving Mr. Musk's argument, and there is certainly no shortage of potential relevant First Amendment tests. Mr. Musk and the SEC principally argue about three: the AZRH test, under which the government may compel disclosure of truthful, uncontroversial information so long as the disclosure requirement is not unjustified or unduly burdensome and does not chill protected commercial speech. That one makes sense. The Central Hudson test, which asks whether the government's interest is substantial, whether the regulation directly advances that interest, and whether the regulation is more extensive than necessary. I'm not sure how applicable that one would be. And third, strict scrutiny, which I doubt is very applicable, which requires the government to prove that the restriction furthers a compelling government interest and is narrowly tailored to achieve that compelling government interest. I'm very well aware of that one. The court concludes that strict scrutiny does not apply and that the challenged aspects of Section 13D survive the Central Hudson test. Oh, that's the one they went. Thus, the court need not conclusively resolve whether Xander or any other less strict test governs. Applicable standard. Mr. Musk argues that the constitutionality of Section 13D must be assessed under strict scrutiny. The SEC argues that Section 13D's constitutionality should be assessed under the permissive AZRH test. The court declines to apply either test and instead applies the Central Hudson test. Strict scrutiny. Mr. Musk urges the application of strict scrutiny, arguing that Section 13D makes a content-based distinction. If a qualifying investor purchases securities with the purpose of acquiring control of the issuer, she must disclose that purpose in a Schedule 13D. If an investor lacks that plan, she may instead so certify in a Schedule 13G. This argument, however, has been foreclosed by the D.C. Circuit. The circuit has held that securities regulation involves a different balance of concerns and calls for different applications of the First Amendment principles than other regulations. The distinct category of speech relating to the purchase and sale of securities is one in which the government's power to regulate is at least on board as with respect to the general rubric of commercial speech. In other words, in this circuit, the applicable standard is no more restrictive than the Central Hudson test. Oops. The DC Circuit's approach accords with the Supreme Court's identification of the exchange of information about securities as an example of commerce-related communications that are required without that are regulated without offending the First Amendment. The court notes that even if it were we're writing on a blank slate, it is doubtful on a blank slate. It is doubtful that strict scrutiny would be appropriate, the appropriate standard. Mr. Musk argues that Section 13D is a content-based regulation on speech subject to strict scrutiny because it specifically targets the communicative content of an investor's strategy and intentions, and exposes different filing requirements based on those strategies and intentions, or imposes different filing requirements based on those strategies and intentions. But this argument proves too much. Under the logic of Musk's position, all disclosure requirements would be content-based regulations subject to strict scrutiny. After all, well, I mean, that is what he wants to do. He wants to make it so that there can be no regulations against. That's kind of what he's angling for, and yeah, not even a conservative court, I think, would go with him on that one. Yet courts have upheld many disclosure requirements without applying strict scrutiny. Yeah. Application of Central Hudson, since that's the one that they're going to go with. The court's going to go with. Under Central Hudson, protected speech may be regulated if the government interest is substantial. If so, then the court must determine whether the regulatory scope is in proportion to the interest, and inquiry comprised of assessing whether the chosen means directly advances the state interest involved and whether it is narrowly tailored to serve that end. The court addresses each of these requirements in turn. Okay. That pretty much kills that. Oh, here we are. Unconstitutional vagueness. Next, Musk argues that Rule 13D is unconstitutionally vague. An enactment violates the Due Process Clause if it is so vague that it fails to give ordinary people fair notice of the conduct it punishes, or is so standardless that it invites arbitrary enforcement. If the law interferes with the right of free speech or of association, a more stringent vagueness test should apply than if it does not threaten to inhibit the exercise of constitutionally protected rights. The purpose of vagueness rule is the purported vagueness is Rule 13D1's directive to file a Schedule 13D within 10 days after the investor's qualifying purchase of securities. Mr. Musk says that days could mean either calendar days or fucking. Are you fucking serious? That's what you're going with? This ambiguity does not require dismissal of the SEC's complaint. In general, individuals who engage in some conduct that is clearly prescribed cannot complain of vagueness of the law as applied to the conduct of others. And here the complaint alleges that Mr. Musk violated Rule 13D1 under either the calendar day or the business day interpretation. That's pretty funny. Selective enforcement. Next up is Musk's claim of selective enforcement. The equal protection component of the Due Process Clause, the Fifth Amendment, constrains the government from making a decision whether to prosecute on an unjustifiable standard such as race, religion, or other arbitrary classification. The premises of this argument are underdeveloped. First, it's unclear whether a defendant in a civil action can raise a selective enforcement argument. That's pretty fair. Musk does not address this question at all, despite the SEC raising it in its opposition. But granting the premises for the sake of argument, the court must apply the rigorous standards that defendants must meet before even obtaining discovery on a selective enforcement defense. Under that standard, defendants must put forward some evidence tending to show the exercise of the essential elements of the defense discriminatory effect, and discriminatory intent. As some courts have elaborated these elements, the defendant must show that 1. He or she has been singled out while others, similarly situated violators, were left untouched. 2. That the government selected the defendant for prosecution individually or in bad faith based upon such impermissible considerations as race, religion, or the desire to prevent the exercise of their constitutional rights. Mr. Musk falls well short of carrying the burden. The D.C. Circuit has held that defendants are similarly situated for the purposes of selective enforcement claim when their circumstances presents no distinguishable legitimate prosecutorial factors that might justify making different prosecutorial decisions with respect to them. Mr. Musk's argument on the point veers off in an unusual direction rather than seeking to demonstrate that there are similarly situated violators of Section 13D who were left untouched. Mr. Musk admits that the SEC regularly seeks and obtains monetary penalties against individuals for late filings under Section 13D. He rests his argument instead on the assertion that he is the only individual or entity for whom the SEC has ever sought disgorgement under such. God, these are so fucking weak arguments. Weak sauce. The court will again assume that such assertion could prevail. Still, Mr. Musk has not put forward some evidence tending to show another Section 13D enforcement action in which the SEC did not request disgorgement. Jesus. This is bad. Bad. Oh my goodness. Wowza. Motion to strike, challenges to relief. Okay. Well, I think that pretty much covers that. Let's see here. How much time do we got left? I don't think I'll go till 11 like I thought I was going to. I think we'll cut it loose here. I got to the topics that I wanted to, and that was kind of a load of fun. Unless I see something on Pacer. Let's just for funsies check Pacer real quick. Let's check Pacer real quick. What's on Pacer that could be fun?